All rise. Court of Appeal for the District of State of Florida is in session. Carrie Whiteman, Judge. All things for your good attention and shall be without serious State of Florida. You may be seated.
Okay, good morning and welcome to a session of the 5th District Court of Appeal. As was mentioned, I'm Kerry Vander. I'll be presiding. To my right is Judge Alan Lawson, and to my left, Judge Jay Cohen. We have two cases scheduled for oral argument this morning. The first is a criminal case. Each side will have 15 minutes. The second is a civil case. Each side will have 20 minutes. Go ahead and start with State of Florida versus EMMANUEL Mendez. How much time would you like for rebuttal?
Thank you, Judge Vander. 5 minutes, please. Good morning. May it please the Court. I'm Assistant Attorney General Mary Jolly on behalf of the State of Florida. This is an appeal out of Osceola County on an order granting the defendant's motion to suppress his statement. It's our position this morning that the trial court erred factually and legally in its determinations, and what's rampant through the order granting the motion to suppress, we think initially, is that the trial court relied on the Sixth Amendment right to counsel, which clearly wasn't applicable at that instance. The issue before the circuit court and what it should have...
I'm trying to figure out what difference that makes, because the case law that he applied really applies to the Fifth Amendment right to counsel. So
well,
the fact that he said Sixth Amendment right doesn't seem to matter.
I think what matters about it, Judge Lawson, is that his rationale as analysis seems to demonstrate this sort of offense-specific right, and it gets wrapped up around the axle, or a red herring, if you will, about the civil writ. And the issue really is there a Fifth Amendment invocation of his right to counsel? And we don't dispute.
I don't understand how that helps you, because the Sixth Amendment right to counsel is offense-specific.
Correct.
The Fifth Amendment is not offense-specific. So once a defendant invokes his right to counsel, what is there to clarify it, whether it's this or that, if it's not an offense?
Again, it doesn't matter, really, essentially, for our purposes, but I think I just wanted to clarify that aspect. This is a Fifth Amendment invocation right to counsel. Sixth Amendment's not there yet. We're not at critical stage. And we don't dispute that he invoked his right to counsel. There's no factual dispute from either the DVD video, which the trial court, for some reason, technologically had trouble listening to. I've yet to have a problem with it the 4 times I've watched it on 4 various computers, or the transcript. Under either factual version, which no one disputed the facts in the transcript,
The trial
that
judge
he invoked.
Let me ask you, the trial judge
Yes.
is the trier of fact.
Correct.
Are you suggesting that if we listen to the tape, we can form our own conclusions about what's being said, or do we have to give any deference to the trial court on what the trial court found?
Generally speaking, Judge Evander, we give deference to, obviously, to a factual finding of the trial court. The factual finding would be what was said by the defendant in this case. But this case offers this court the opportunity under Dooley and Almeida to watch it firsthand from the video. And the video is plain. He invokes. He waits 5 seconds. Everything stops when he invokes his right to counsel. It's quiet. Deputy Brown continues writing. At least 5 seconds elapse on the tape, and then he brings up this notion about the purge or the writ. That's an initiation by him under Oregon versus Bradshaw. That's plain from the tape. If the court considers the transcript, while it doesn't give you that time lapse that's demonstrated on the video, they discuss the purge, which is, again, an initiation by him, by Mr. Mendez, saying, let's have another criminal conversation here. That's clearly an initiation under Oregon versus Bradshaw. When we're dealing with that, it's an engagement by the defendant, not by the officers. When we're under those facts, we have a 2-part inquiry. Is there an initiation, which the facts demonstrating under the tape or the transcript demonstrates that there was? Then after that, is there a voluntary waiver? And it's our position that plainly there was. They went through it again. The defendant said, yeah, let's do it. He signed the sheet, and he talked at length about this crime. No holding back at all after that point in either the transcript or the tape. So it's our position plainly under Oregon versus Bradshaw and the cases out of this court that have applied it, both Bryan, Blackburn, and I think particularly Perez out of the 3rd, all support the position that he engaged, he started, resumed, and wanted to talk about these criminal investigation. The waiver was done, and that's exactly what he did.
Are you suggesting that factually there aren't portions of this recording that are effectively inaudible?
Judge Cohen, from the state's position, no. I think the tape, the video is plain. And again, I spent a lot of time not re-watch, but making sure that I could get it for clarity purposes when I watched it, and the disc I have is fine. The judge seemed to have an audibility problem, but nevertheless, even the transcript, which went undisputed by the parties at the suppression hearing, demonstrates from that dialogue in the transcript that the initiation came from the defendant. But I do think under Dooley and Almeida, this court can listen to or watch the tape and listen to it, obviously both, and make that determination as to, I just don't think that his factual finding that it's completely unclear is unsupportive.
Not every initiation of communications by a defendant is going to prevail on the two-tier process, correct?
I agree with that, certainly. And there are cases where an innocuous comment, may I have a drink of water, the courts have said that's not a re-engagement or an initiation of discussion, but this is clearly about what he's there for. It's akin to what are the charges in Perez. It's not the same. It's analogous to that. This was clearly a decision on his part to re-engage the officer, to have a discussion about what those criminal charges were and what they were there for. And he wanted to, I'm sorry.
Assuming that it appears that the defendant is watching the investigator fill out paperwork and is asked some questions about that paperwork.
Correct.
Would that, in your view, be sufficient?
In terms of the just looking and he gestured to the paperwork and then made the inquiry, and that's the initiation. Yes, we feel that that's.
What do you think that inquiry said? What do you think that the defendant said at that point?
After he invoked, and they had, 2 or 3, you do, yes. 5 seconds elapsed. Our position is he's looking at the paper and says, so that's for the writ. And the deputy says, huh? Yeah, and that's when the reinitiation starts to, and that's what we feel happened based upon our review of the tape. Now, the transcript doesn't mention writ. It goes right to, that's what for the purge. Either way, they're analogous, and that's him coming to that.
Let me ask you about that. So
Sure.
is it your position that the state's transcript is not 100% accurate, that there's actually, you can hear more from the tape that's in the state's transcript, or are you asking us to rely on the state's transcript?
I think you can rely on the tape and look at it on your own.
You think the tape has more or different than what's in the state's transcript?
I think what the tape has 2 initiations by him. Is that for the writ? Is that the purge? The transcript goes right to, is that the purge? So I think we've got a double engagement by Mr. Mendez on the tape, but we certainly have it based upon the transcript. And the transcript went undisputed below. However, both of the parties were under the impression that the trial court was going to watch the videotape before he ruled on the motion. So that was admitted into evidence, and they said, I know Mr. Wesley said at the suppression hearing, go ahead and watch the video. But I think under either factual scenario, there is an initiation here. That's not disputed, and then there's a valid waiver after that. So that's our position. It's a little difficult when we have some sort of audio issue with the trial court, but this
Whose burden of proof is it? The defendant made an unequivocal request for counsel.
We don't dispute that.
All right, so it's the state's burden of proof.
A burden to show.
And if for whatever reason the quality of the recording in this digital age is ambiguous or unclear, then isn't the trial judge justified in finding that the state didn't meet its burden?
I don't think the trial court is justified, Judge Cohen, because the transcript doesn't support that finding either, that everyone stipulated to, where there is, again, an initiation plainly when you read the lines of the transcript.
What do you mean the transcript was stipulated to?
The
Was it stipulated into evidence? Or
It was admitted into
stipulated that it
evidence.
was an accurate representation of?
The parties agreed, and I will, on rebuttal, I'll check the record page, but my understanding of the record, and I don't want to misstate, was that there was, we'll accept the transcript too. I'm sure my counsel will correct me if I'm wrong about that, but I'll check. So under either scenario, there is an initiation, an engagement by the defendant under Oregon versus Bradshaw, which then warrants that inquiry, and we believe that the trial court was just legally wrong in its conclusion thereafter. I'm going to hold off with 6 minutes to go and wait for rebuttal. Thank you.
Please, the court. I may be a stranger in your strange land, but I did litigate this motion below, and I'd like to talk to you about, I'm glad that Judge Cohen noticed that there is a heavy burden on the state to prove a waiver once there's been an invocation.
Let me ask you about the burden of proof. If it's a technology problem, then I can see where the burden should be on the state. They have the ability to put in better technology. If the problem is caused by the manner in which the suspect speaks, is there a higher burden for the state, or is it just the trial judge tries to ascertain to the best of his or her ability what was said by the suspect?
Well, Judge, if I can answer it with a narrative, here's what I'd like to say happened. The state attorney made a strategic decision to abandon actual testimony from Investigator Brown. When Judge Morgan chose to interrupt his testimony and was incredulous about the purge matter, saying you're questioning him about a collections court, the state attorney then, as the transcript shows, decided to go only electronic. She decided not to put her officer's credibility in anymore. If there had been no tape recording at all or no videotaping, she could have still tried to prove the point and meet her heavy burden with the live testimony of the detective that was in the room. It was received, as I say, with some skepticism by the trial judge, and then she went to the point, let me just play this, and decided to rely solely, strategically, on the tape. When the tape and the transcript were offered, I said, for purposes of this hearing, we have no objection to their admission. There was never a discussion about authenticity. When the audio...
Go ahead. On the transcript, did y'all stipulate that the transcript was an accurate representation of the conversation between the detective and the suspect, or was it just a stipulation that it could come into evidence and the judge could give it whatever weight the judge deemed appropriate?
Judge, we did not stipulate to the authenticity. It was not offered that way. It was offered as an exhibit, and I said that I agreed to it for purposes of the hearing. But when the state first started to play the sound recording, she indicated that, I'm sorry, I can't hear it. The judge said, I can't hear it. We said we can't hear it. And then the state, without asking the live witness who was present what happened, what took place, how did this occur, said, maybe you can listen to it in chambers, Judge. And we agreed with that also. We agreed to submit it to the court.
Mr. Wesley, a copy of that has been attached as part of the record on appeal.
Of course.
And so we are capable of listening to that, and we have listened to it. Is there any difference once we have the same ability that the trial judge had to listen to that evidence? Is the trial court's factual determinations, is there any deference given to the trial judge's findings of fact?
Yes, Judge, and under Connor, I think that you're obligated to give great deference to historical facts. I think the state's suggestion that everything is on the table and for de novo review would be upsetting and unsettling to say that trial judges, especially with the diligence shown by Judge Morgan, yes, I'll take it in my chambers, yes, I'll listen to it multiple times, yes, I'll try to unravel it, and then with Judge Morgan saying, I find differences between the tape and the transcript, then to say in an appellate court, just look at it all over again.
What would be the difference between the situation we're in now in a situation where, for instance, a trial judge in a case reads a deposition and makes findings based upon the deposition? When that comes to the appellate court, we are in the same position that the trial court was in, and therefore we give no deference to the trial court's findings vis-a-vis the deposition. Why wouldn't the same concept apply to the DVD?
Well, Judge, I think that I have to acknowledge Connor says that, and Connor was a death penalty case where the question was whether the person was actually in custody and whether the waiver was made in custody. So I understand in important cases that judges are going to look at the record, and that may include electronic means too. I'm actually pleased that you saw it, because you see in the tape that the detective's knees are virtually touching Mr. Mendez's knees, and Mr. Mendez is looking at the writing, which I suggest in your question of the state shows that Mr. Mendez shows the concern of an uninitiated criminal defendant that he's being graded or tested, and they failed the test because the officer is sitting there writing when he says he wants to invoke counsel. And what I'd like to ask you to look at next is, whatever the language is, the state then has the heavy burden of proving reinitiation. and they're saying there's a question about the purge. Some of the gamesmanship that is involved here is Detective Brown has an arrest warrant in his vest pocket. And yet he said that this was that he was arresting a man for a collections court matter for an unpaid financial obligation. He also says in the transcript that there was a pre-interview. We know that without any other details. There was a pre-interview. He takes the man in and starts talking about, the man says, I want a lawyer. And then he said that there's some language about that's for the purge, says Mr. Menendez. But then it's the officer himself, given a clear invocation, which the state stipulates to. The officer says, what about the other thing? The officer is saying. And then the client says, what? And he says, the murder. This is what we're talking about, the bright line of Edwards versus Arizona. You know, the state has relied upon Oregon versus Bradshaw as the main case they wanted to cite to you today as the United States Supreme Court case on the question of what's going to happen to me now is the reinstitution of questioning. If you would please look at the facts of Bradshaw. Bradshaw was on the second time he was Mirandized and interviewed, on the second interrogation, asserted his right to have counsel. The next day, he was being moved, and he asked the officer who was moving him, what is going to happen to him now? And the officer, scrupulously honoring the invocation, said, you don't have to talk to me. The officer did. At no point did Detective Brown in Kissimmee, Florida say, you don't have to talk to me. At no time did Detective Brown unhinge his knees and stand up. I suggest the case law shows attenuation being a key to Edwards' adherence, that someone leaves the room, that the officers leave the room.
Did the investigators' body language or issues of the pre-interview play any part in the trial judge's ruling?
I don't think so, sir. It was not gone into, but it was discussed that there was some discussion, and then the recording began.
Let me ask you this.
Yes,
There's
sir.
at least three sets of, facts, if you would, floating around. There's the state's transcript that was put in evidence. There's the trial judge's findings as far as what the trial judge could hear or not hear.
Yes.
And then the prosecutors argue that, if you listen to the tape, you can actually hear at least one more line that isn't in the state's transcript. Do you feel that your client prevails regardless of the three, or do you think maybe if the transcript's accurate, your client's in trouble, or does it matter which of the three that we find, if any of the three, as far as the results of this case?
Judge, I don't think the bugaboo is in what words were spoken. I think it's in the conduct of the detective after the invocation, that he continued to sit there in close proximity and write at the paper as if he's waiting for more, as if waiting for something to be said. And then when
The time frame was very short.
Of course, Judge. But I think that the state is trying to put lipstick on a pig when they say the time was short, because if the time was long, they would say the time was long. I mean, one of the confusing things to me in the state's brief is that they...
But your insinuation is that there was some impropriety on the part of the detective, some gamesmanship. And it doesn't really appear that there was time for a lot of gamesmanship.
But the detective needed to take some action to the invocation. Again, the state has said it was...
Don't they do that by stopping questioning?
But the state agrees there was a clear invocation. But what Detective Brown said, I was just trying to clarify the invocation. Well, how can we have a stipulated clear invocation? Do you want a lawyer? Yes, I do. I was just trying to clarify that. That's why I was saying, what other thing? What murder?
Well,
and
if the defendant interjected the ambiguity by reinitiating a conversation, is an officer then allowed to clarify?
If he had asked questions, if he'd said, this is for the purge, yes. The next question then, Judge Lawson, was, what about the other thing? And Mr. Mendez goes, what? And he goes, the murder. That's the detective saying, let's get back on track here. Let's do what we're working on. And then a few lines later, you're saying, this is especially troubling, given Almeida, about the officer's duty to give a true response. He said, it's not going to do me any better, it's not going to change things if I talk now or later, right? And the officer goes, you're exactly right. This is in the middle of what the state relies on as the waiver process, the second waiver process. And Almeida is where the person says during the Miranda warnings, what good is a lawyer going to do? And the officer gives an answer, well, it's not really going to help much. that you can always have a lawyer later on. We say that that's part of the taint too. When you say, well, it's going to be the same as if I talk now, as if it's not going to change if I talk now or later, that's right. That's exactly true. And given the bright line, and given the fact that that's the warning process, that's what's violative. I point that out. In Bryant, in Bradshaw, and in Blackburn, all the cases are all cited by the state. There's attenuation in all of them. There are incidents where the interview is over. I wanted to talk to the lawyer, the two officers leave, the ATF agent comes in, and then the fellow says, where are they going? He says, well, they're going back to Florida. And he goes, what are they going to do? They're going to talk to the co-defendant. Well, get them, would you? I mean, there are these kind of situations. But there's nothing to show.
Do you think Brian would have been differently decided if instead of the first set of officers leaving the room, they get up to leave and the defendant says, where are you all going? I mean, if you had that short a time frame, do you think Brian would have been decided differently? I mean, I know in Brian, the first set of detectives left the room, and then the second set came in and said, where are they going? But what if, he says, you have a right to an attorney, do you want one? Yes. Okay, thank you. And they get up to leave, and before they even exit the room, the person says, wait a minute, where are you going? I mean, do you think Brian requires that they walk out of the room, or that it be 10 minutes or 5 minutes, or is the key focus on who initiated the next dialogue?
Well, the reason I don't know to give you a case cite is because those are winner cases, I think. Those are cases that weren't appealed where the confessions were suppressed or evidence was suppressed and they weren't brought up as this one was. We always see the cases where the defendant loses, which there's sufficient attenuation. That's the history of Edwards, is finding what totality of circumstances took place before.
Is it your argument that the bright line test and the statement that law enforcement has to scrupulously honor a defendant's request for counsel means that really at that point when the defendant said something else, the officer had to say, you said you want a lawyer, we can't talk to you?
I think there has to be some indication of what I've seen and what I think the practice should be, some indication I've heard your assertion and I'm going to respect your assertion, rather than like echoing answer like a bad cross-examiner, like, what did you say, or are you sure? And I think there are different techniques to show this submission to apparent authority. The setting in the room where everyone's clustered on one side, sitting at the table, continuing to write as if you're grading a test. There are a million ways to show that we're just going to sit it out, rather than just say, okay, given the fact you want a lawyer, let me know if you change your mind, or I'm going to go get the lawyer. Some of the cases even show that the officer had gone out to try and secure the services of counsel when the defendant reinitiated. And I understand that, and I think that's fine, but it shows the great adherence that the officer had to the Edwards bright line. Detective Brown was going to take a statement that day. He was first going to do it by bring somebody in on a collections court writ with the warrant in his vest pocket, and then talking to him, and then springing it on them. He was going to take a statement, and I think
the warrant in the vest pocket that's in the record.
Well, yes, Judge. That's why I said the issue of the purge was the discussion about the purge. That there's a purge. That's what I think is confusing. That the state says that there was no right, no Sixth Amendment right for Mr. Mendez at all until he was charged by information a month after the interview. I think that's extremely disingenuous to make that argument. That's in their conclusion on the last page of their brief, that he had no right to a Sixth Amendment right to counsel, which would indicate that there was no service of the warrant, that it was just a guy who was a suspect in a crime, when he wasn't a suspect in a crime. There was probable cause, and an arrest warrant had been issued already by Judge Draper. The problem we have is that is not the quality of the transcript. The problem is the adherence to Edwards, and that the questions follow are not harmless or innocuous conversation. What about the other thing? The murder. Well, I guess it's not going to be any different talking now or later. Yeah, you're right about that. I think that's the gravamen of it, and that's what we ask you to focus on. Ready for any other questions if you have them? Otherwise, I thank you for your attention.
Thank you.
Thank you very much.
Two things, and I just want to start off where he led off. Let's look at the tape, which under Dooley and Almeida, they say insofar as this, because it's based on an audio videotape, the trial court is in no better position to evaluate the evidence than the appellate court. That's Almeida, and that's the Florida Supreme Court. So that's that issue. With regard to this reliance on Almeida about the comment that he makes, it's not going to do me, whatever that allude, he said, let's look at the tape, let's look at the transcript. There's a lapse there. There's 10 seconds of silence before he makes that rumination. It's not a clear question under Almeida. It's basically amusing. It doesn't invoke Almeida, and there's had already been a waiver. So I think that argument should be rejected by this court. Almeida is not controlling here with regard to his rumination, and he waived at that point. He had waived before it. He had said, man, you don't even need to go through that again. I'm going to waive, I'm going to talk, and he initials it. There's a lapse of 10 seconds of quiet before he makes that comment. So I don't think that Almeida comes into play here at all. I think this court has hit the issue, the nail on the head, and I think that what this court needs to look at is there an engagement and initiation by the defendant? Absolutely. On the tape and on the transcript. And it's our position that once that re-engagement came in, Detective Deputy Brown talked to him. He doesn't have to sit there silent, and we shouldn't be punished by the fact that Mr. Mendez waited 5 seconds to talk before they could get out of the room. They didn't get out of the room in Perez. They didn't get out of the room in Blackburn, which was a state appeal.
Let me ask you this.
Yes.
So you would agree that the record reflects that the detective brought him in under the guise of a writ, collections court writ, but had an arrest warrant?
My understanding of the record, and on the arrest warrant is on page 2 of the record. That was the day, July 21st, that he came in on the murder and the writ. That's what he testified to at the suppression hearing, and the arrest warrant is in there for the murder on the second page of the record. I just checked. So, no, my position is no, he did not just come in on the writ. He came in on both. And no, we don't know what happened before that, Your Honor, in terms of that pre-interview. That's not in the transcript.
That would be the state's burden to show what happened pre-interview. If there's an absence, it could be, and that evidence might be significant, that could be held against the state, right?
Arguably, but I don't think it is here when we have a plain initiation by him. That fact is clear, and it's undisputed.
Well, under Edwards, if the defendant had said, listen, I don't want to talk to you, I want a lawyer, you would agree that the officer could not say, well, we were talking about the collections court writ. What about this other thing? Do you want to talk to me about something else, about the murder? That would be completely prohibited.
That's different
right?
from what happened here.
And how is it different?
Mr. Mendez said, I don't want a lawyer. I want a lawyer. They run through those rights.
I want to talk to you, want a lawyer.
Yes. He's writing, you do, yeah. Silence. He doesn't say anything to him. He's looking at what he's doing and says, is this about the writ? That's an engagement. That's engagement. We're going to have some sort of conversation here. And the officer answered him. So that's for the writ. He says, huh? You know, that's for the warrant, that's for the writ. And then they talk over each other on the tape. Brown talks over and says, you haven't opened, and he cuts him off. The defendant says, for the purge, right? All right. And that's when he says, well, what about the other thing?
If the defendant says anything.
I'm sorry?
It's your position that if the defendant says anything after invoking his right to counsel, the officer can then go back and try to reinitiate the interview.
No, that's not my, not anything, and I think we talked about that during my initial argument. I want a glass of water, no. But when it's coming to the fact that why they're there and what the charges are.
I mean, to me, is that the writ isn't much different than I want a glass of water.
I disagree with that, Judge Lawson.
He's looking at what's on the table next to him and says, is that the writ?
And he'd been brought in, I'm sorry, I didn't mean to talk over.
How does that open the door for the officer to reinitiate the
I think it goes back to the fact that he's there on both of those. He had been brought in on the arrest and the writ. And it's about the circumstances that what he's exactly there for. It's not an innocuous, I need a drink, or I need to call my parents. You know, it's nothing like that. It's about what they're actually sitting in that room for, and that is an engagement by him.
But what gives me some difficulty is that I'm not so sure that you can tell exactly what he said. You know, you're saying, is that the writ? You know, I'm not so sure that you can tell exactly what he said, and I don't think that the trial judge could discern exactly what was being said. And under the theory that the burden of proof is upon the state, if that's so, then this is an affirmance, is it not?
No, because I think the transcript alludes to the fact that after there's this writ comment, which you clearly have an issue with, then there's another comment clearly about the purge. So there's yet another initiation by him. That's in the transcript. to, so like when I argued before, we think there's two clear engagements by Mr. Mendez on the video DVD. The transcript demonstrates one as well. So if there's an inaudibility with the writ comment, there certainly isn't one with the purge comment, which is evident in the transcript.
Is that the writ, if that comment is just saying, is that piece of paper in front of you the writ, versus is that the writ, meaning, are you talking to me about my right to counsel on the writ matter? Would you agree those are significantly different questions?
I still think, Judge Evander, and I don't mean to reiterate, that it's still an engagement about a conversation about what they were there for, and I do think it's an initiation on his part to have a discussion. And the totality of that, of the circumstances that are evident from the tape is, he made the decision that he wanted to talk about the murder, and he did at length afterwards. He knew to invoke his right to counsel. He did, yeah, no, I don't want to talk. You want a lawyer? Yeah. And then he re-engages, and it's clear that he wanted to talk about the murder. So I think the totality supports that finding. What Oregon versus Edwards and Bradshaw, it's all about badgering. Oh, I went over. It's a first. Anyway, we'd ask this court to, again, review the audio, and we'd ask that you reverse this case. Thank you very much.
Thank you both.
May I correct a misrepresentation on my part, judges?
Okay. Go ahead.
The order, Judge Morgan's order, does reflect that he was arrested on both the writ and the Judge Draper's warrant. It's in the order.
Okay, thank you.
There were two separate deputies and two separate arrests, but I wanted to make sure that I didn't.